Hello and welcome back to the video updates. It's Sade. Today's video is going to be one of those videos that I promised that I would make to help people that are working in the overage business, to just make your life easier and to make sure that you are not going after the wrong leads. This video is going to help you to quickly determine how to figure out who might be a claimant that's entitled to the excess proceeds that you're looking at the moment. So most of the time when you're working on these files, hopefully you find files where there's a named defendant who happened to own that property right before the foreclosure took place or before the tax sale took place. Some of the time you might have a difficult time determining who is who and who actually owned the property. The typical rule of thumb is that the party that owned the property as of the date of judgment is going to be the party that will be entitled to those excess proceeds. Let's say there was a lawsuit filed in 2015 because I didn't pay my property taxes on my home, and then it took the county about 2 years to finish up the case until they got a judgment, right? So they got a judgment in 2017. In 2016, I went ahead and sold that property to someone else. Maybe I didn't tell them about the lawsuit, maybe they knew about it and they didn't care. As at the time of the judgment in 2017, that means the judgment would say that it's against me and my property. But in 2016, because I transferred that ownership interest to someone else, it's quite possible that that other party is going to be the one entitled to those excess proceeds. So check with the lawyer that you're working with to see what your state says about it. But generally speaking, the party that owned it as at the date of judgment is going to be the one entitled to those excess proceeds. So that's one thing that you have to keep in mind as a general rule of thumb, but make sure to check with a lawyer in your state. I'm just speaking as far as Texas goes for those tax sales. Now, what about the situation where the party is named inside the lawsuit? Sometimes the counties would list several parties that they think might be interested parties, meaning that they might have interest in the real estate. So they list everybody just to be on the safe side so that they don't have any liability in the future. So sometimes they list 4 or 5 different people that potentially could be claimants to those excess proceeds. So then you have to determine who might be the most likely claimant to succeed, who has the highest priority out of all those people. And it's going to be the party that had the name on the deed, either at the time that the case was filed or at the time that the judgment was entered in the case. And sometimes you wouldn't know that, but at least you can figure out who owned it at the time right before the case started. So that is one way that you can also do that. If you don't have any idea, just go with the party that's listed in there as the defendant. Sometimes it's only one party that's listed, and that makes your life a lot easier. So that would be the right party, most likely, that will be entitled to the excess proceeds, of course subject to any other liens that are out there. Now, what about the situation where the party is deceased? That's the one where people get stuck and they go after relatives and whatnot. Now, you don't want to go after relatives blindly because when somebody dies, there is some sort of process that determines who the legal heirs would be. If somebody died with a will, of course, you look at their will to determine who inherits what, right? The will would tell you, oh, my daughter inherits my car and my house, and my son can inherit everything else, something like that. So the everything else, that excess proceeds would fall into the category of everything else. We call it inside the will the remainder, residue, and rest of my estate. So that's pretty much the language that they use, and it just means anything else that I left out in my will will go to this particular person, or it will go to all of my heirs. And so the will would determine if there's a will. The will doesn't automatically get accepted in a case just because there's a will and somebody said, oh, here's a will. The court would like it to have gone through probate court first. The probate court, of course, being the court that oversees things to do with estates. So your lawyer would be able to check to see if the probate was done already. And if the probate wasn't done, the lawyer can still do it if it's within the time frame. If it's outside of the time frame, then you have to look to see what are the default laws when somebody doesn't have a will. Because if I had a will and I passed away 10 years ago, and the law in my state only allows us to probate wills within 4 years, like Texas does, then that means my will cannot be probated anymore, most likely. So it's almost as if I passed away without a will at that point. So if I passed away a long time ago and nobody did anything, then you might have to end up using the default laws. But speak to the lawyer in your state to see what the process looks like. Now, this video is for educational purposes as always, and to just give you some guidelines to keep you from spinning your wheels and wasting a lot of time and effort chasing down the wrong parties. So if there is no will, which is really, I say 70% of the time, most people don't have a will, and it's just the way it is. If there's no will, then how can you quickly determine who is the right party to pursue, or who's the right party to contact to see whether they might be the right claimant for these excess proceeds? So if there's no will, generally you can safely talk to the spouse if the person was married at the time that they passed away. Ex-spouses don't count. Somebody that they married 20 years ago and divorced from, that person doesn't count. So it has to be somebody that they were married to at the time of death. So that would be somebody you could talk to. The other people that could likely be legal heirs would be the children. The children are typically legal heirs. So you would be able to find the children and inform them that you think that they're entitled to some excess proceeds from their deceased parent. And then you can transfer the files to the lawyer, and the lawyer would do the rest. So those are safe bets when it comes to figuring out who are the legal heirs, okay? If somebody passes away and there's no spouse, that means person wasn't married at the time, and there are no children, that's the only time you start looking at their parents, if they have parents that are alive. If they don't have parents that are alive, then you can start talking to their siblings, because those people will come into play if the person doesn't have any children or any spouse, okay? So that's my quick overview for you on that part of the whole deal. The related question that people have is, what if I do know that the person never had any spouse at the time of death and they only had children, and now they had 4 children, and I can only find 2, or I can only find 2 that are agreeing for me to help them with the excess proceeds. If you can only find 2 out of 4, it doesn't destroy your efforts at all. It doesn't really stop you from moving forward. The lawyer should still be able to file a claim for those 2 kids. The only difference is that they can only file a claim for half of the excess proceeds. So let's say there's $40,000 there in excess proceeds and you have 2 of the 4 children, then the lawyer can move forward and file a claim for $20,000. $10,000 to one child and $10,000 to the second child. And then the remaining $20,000 is just going to sit there in the court registry, and or with a trustee if it's a mortgage foreclosure. It's just going to sit there until somebody claims it, or it might escheat to the county or to the state at some point in the future once the period of time has lapsed. So it goes to the county or the state. Hopefully the other children do come around later on to claim their excess proceeds before the expiration period, or before it's turned over to the state. If it's turned over to the state with the mortgage foreclosures here in Texas, they still have a chance to claim it. It's just a lengthier process and it's more involved. So just to recap on this, remember the rule of thumb is that if there is a defendant named in there, it's safe to go after that defendant if they're alive. If the person is no longer alive, think about whether they were married at the time of death, if you can find that out really quickly, or if you can find the children, always a safe bet. If there's no spouse or no kids, then that's the only time you start talking to parents. But parents first, if the parents are alive, followed by siblings, okay? So those are the things that can help you with making your life easier when you're looking at these files. As far as the defendants that are companies would go, you want to find the president of the company if it's set up that way. If it's an LLC, then you find the managing member of the LLC or one of the managing members of the LLC, and you can figure out, you can ask more questions and send the file over to the lawyer. The lawyers are the only ones that can make the final determination as to who the right claimant would be. But at least you make your life easier if you go after people that are pretty close in line, or go after the people that are most likely going to be the claimant in the end. And then, of course, the lawyer would take care of any heirship that needs to be determined, any inheritance that needs to be proved up. And the lawyer can also take care of whatever orders need to be obtained from the probate court in order to then file a claim for the excess proceeds. It's not always needed, but it's needed in some cases for sure. So that's why this work it takes some finesse. You have to take your time and don't try to do more than is needed in your role, because the lawyer is still going to do the due diligence and do all the homework. But don't go after random relatives, because that would be wasting your time. And definitely go after the ones that could most likely be the parties to inherit. And don't worry about whether it was marital property or separate property or community property or anything like that. Those things are very difficult to determine without having gone through a lot of training to be able to figure that out. So because it depends on a lot of factors, depends on a lot of analysis that needs to be done. So you just wouldn't know. But those are some guidelines that should keep you in line when you're doing this type of work, and it should keep you going and able to move forward and be successful at this. So hopefully you have some takeaways from this video. For anything that's specific to a case you're working on, remember, this channel is for educational purposes only. We cannot answer specific questions like that, but you can definitely talk to a lawyer in your state for those kinds of questions, or if you are in Texas, you can email us and we'll be happy to discuss at that point. So that's what I wanted to cover today, and I promised that I will do some of these videos every now and then to help you out with your overage work. So hopefully this has been something that you can use. And if you like the channel, remember to subscribe and let us know also what you want us to talk about on the channel, and I'll be happy to cover them. Thanks as always for watching, and I'll talk to you next time.